Hello, and welcome again to another episode of the Hathaway Kunz podcast, where we discuss all things legal in the state of Wyoming. Today, I've got with me John Fritz and Jeremiah James, attorneys with Hathaway Kunz. And today, we're going to unpack and spend a little bit of time discussing and maybe dispelling some myths surrounding trusts and the use of trusts in the state of Wyoming, and specifically surrounding the application of some of those trusts and how people might use them. So I'm going to start with some random questions for you guys to kind of orient the audience to what we're talking about, right? So maybe, Jerry, I'm going to start with you. Give our audience just a general idea. Someone calls, they want to set up a trust, just a generic revocable trust for estate planning purposes. What are they talking about? What does that entail, and what does that look like?
Yeah, so thanks for having me, first of all. Happy to be here. So in the context of setting up a revocable trust, you obviously thinking about legacy planning and how do you distribute assets to your beneficiaries, your children, and possibly their children. And so a trust is essentially an agreement for a trustee to hold property for the benefit of the beneficiaries of the trust. That's simply all it is. It's a document. There's some language in the document that's instructional, so it has duties as to what the trustee needs to do with certain property and how and when to distribute it.
And so when we talk about revocable, first of all, am I wrong in saying revocable trusts are kind of the run-of-the-mill trust? Is that a fair statement?
Yes.
Yep. Yeah. John, you were first in nodding. But what do we mean by revocable? Effectively, the grantor, the person like me that would set up a trust, I just have the ability to undo it if I wanted to. Is that what it means?
Basically, so for normal, families or individuals, a revocable trust is really an estate planning tool. So they have the ability typically to revoke the document, to amend the document freely, so swap out any provisions. They can restate it, which is pretty similar to amending it. It just means to swap out all of the provisions that are in the trust. But really, it's really just that, right? It's a revocable document. A lot of it also follows a grantor rule, which I'm sure Jerry's probably going to talk about later today. But grantor trust status just meaning that it's disregarded as far as it being a separate entity. So a lot of folks will say, how do my taxes change when I do a revocable trust? And they just don't. So, a revocable trust is still taxed to the individuals who are the grantors. You can use whatever words you want to use for them, grantors, settlors, or trust makers, but it's just the person creating it. They're still treated for tax purposes like they individually own the trust.
Okay, that's helpful. So hold that thought for a minute, because we're going to come back to revocable trust. But maybe, John, I'll start with you on this one. Compare and contrast that just a little bit with an irrevocable trust, which I think a lot of people sometimes confuse with a revocable trust.
Well, they're irrevocable, so they can't be revoked. But they, it's some different. There's different tax treatments for them. So the irrevocable side of planning, I guess, as a starting point, really all of the families or individuals that we work with, even if they're in the high net worth side, they still have revocable trusts. So it's still kind of the first building block that you go from to have a revocable trust. There's a whole bunch of different types of irrevocable trusts. A lot of them follow different tax code provisions. Or different, just taking advantage of types of assets, basis and types of assets, or just, this isn't a problem that I have, but, I have, somebody who has $2 million, they have a high risk job. And so they want to segregate some of that from any kind of liability that would come from their employment. So irrevocable can either be it could be a whole bunch of different things. Like I said, they're really interesting. Well, I think it's interesting, but I'm a lot of fun at parties. The irrevocable doesn't really mean that it can't be changed, right? There's still some provisions. Sometimes the ability to change what does a beneficiary get? Who maybe defines a class of beneficiaries, maybe, but can be either given to somebody called a trust protector. So sometimes a trust protector is within the document given some ability to change the trust, but there's also a method called decanting, where sometimes, depending on the powers that are inside the irrevocable document itself, you can still kind of amend the document. So You might think irrevocable means I can't change it, but we've always attorneys have come away with a lot of ways to change those things still.
Okay, cool. So we're working through. There's a couple more flavors of this I want to hit on, and then we're going to get to some of the tricky questions. But we've got sort of the revocable trust we've talked about. We've talked about the irrevocable trust. Correct me if I'm wrong, but the trustee, like you outlined, Jerry, in either sense is the person that's essentially legally responsible for the trust and the property in the trust, right? And they're the ones with the duty to make sure that they're following whatever the trust agreement provides for, right? And the beneficiaries are the people, obviously, that get whatever the trust holds. The settlor or the person that sets it up would be the person that forms it and contributes the property to it. For a revocable and an irrevocable, can a trustee be like you? Let's use me as an example. I'm going to set up a trust. If it's a revocable versus an irrevocable, can I be the trustee of my own trust?
Absolutely, yes. So setting up either, if we're just talking about a generic irrevocable trust, like John mentioned earlier, there are several types of irrevocable trust. But if we're looking at just the basic planning type for an irrevocable trust, you could set up that trust and become the trustee if you want. Likewise, the revocable trust, you can. And it's very typical, especially in the revocable trust setting, for the settlors to also be in the capacity of the trustee, just so they don't need any third parties to go through if they need to transact any business or take any action on behalf of the trust or the trust assets.
Okay. So now one more type of trust before we veer off, but we always hear this term when people are calling our office as of late, and I don't know if this is like an internet thing or what, but people are always wanting dynasty trusts or they're wanting dynastic trusts. What in the world does that mean? Who wants to go first? John, go for it.
Dynasty trust just means that they last for a really long time. So there's something called the rule against perpetuities, which is a horrible rule that law students have to read, and pretty much every state has changed it in some way. Some have adopted I don't even know what it's called because we don't do it. There's different ways. Wyoming, in any event, is a 1,000-year period by statute. It's something that the trust has to elect to do. So it's something that, you can say within a trust document that I don't want any of it's called vesting, but I don't want everything to have to come out of the trust to another person for another 1,000 years. So you can elect to have that, and that's what people are talking about with a dynasty trust.
Okay. But otherwise, we're talking about either a revocable or an irrevocable trust instrument of some form. It's just a matter of the lifetime or the planning span of the trust. Is that fair?
I think by the time you're talking about a dynasty trust, it's pretty clearly irrevocable. I guess I'm not really sure in the context of a revocable trust. I mean, maybe you could do it, if it's my trust, maybe when I die, I could elect to have the statutory perpetuities period for 1,000 years take effect. I guess you could do that, but I think if you're going to the effort of doing all that planning, you probably want a standalone document. And if it's a standalone, it's probably an irrevocable trust.
Okay. That's helpful.
But Jerry's got the LLM, not me, so.
All right. So now I want to kind of run through a scenario that we've been getting a ton of in our office, and that's we get a ton of calls lately from people all over the country who, for whatever reason, a lot of times it's crypto related, right? Because they hold digital assets and they know Wyoming's a favorable state for digital assets and crypto. But they call us thinking that they want to have a trust in Wyoming because that's the best place to protect their digital asset wealth. First, Jerry, I'm going to go to you. When you're talking about like a revocable or an irrevocable trust, does someone from somewhere else in the country qualify to have a trust in Wyoming?
So ordinarily, no. One of the requirements for setting up an irrevocable or revocable trust is that the principal of the trust, the settlor of the trust, is a resident of the state. However, our statutes allow us to create trusts where we can have trustees that are within the state, and they could still be able to set those trusts up and still be a valid trust under Wyoming law. So we could have a Nevada resident, for example, or California resident and set up a Wyoming trust so long as a trustee is in the state of Wyoming.
Okay. But that trustee would have to be someone that's specifically designated or someone that's specifically authorized under law to serve as the trustee, and they have to be in Wyoming then. Is that true?
That is correct, yes.
So, John, I'm going to go back to you. Talk to us a little bit about professional trustees. Like if someone from outside of the state of Wyoming wants to come into Wyoming and have a Wyoming trust and have their assets, held in Wyoming for trust purposes, what are their options? What do they have to do?
There's a couple ways of going about it. So there's trust companies that exist. I mean, it's pretty easy, I think, to Google. We work with a number of them, but it's pretty easy to look around and find different, typically banks that run, or credit unions, I suppose, but companies in the state of Wyoming that serve as trustees. In that circumstance, right, it's just a conversation with that institution to figure out what they charge, right, what their services look like, what experience they have. I mean, there's a whole bunch of different places, not just in Jackson, but outside the state as well. There's a number in Cheyenne that do a very, very good job. There's also the ability to have a private family trust company, which is essentially, you're creating your own LLC to become the trustee of your trust. There's some complexities of it that probably aren't interesting to anybody who would listen to this, right? But there's some complexities where sometimes that makes sense, but typically, it's one of the issues you can run into is how much control the person giving the assets to the trust has and maintains in that new trust. And so using the private family trust company, we can separate it to a certain extent. So they still have some authority over the trust assets. It's just not complete authority, and certainly not authority that would run them into any issues with the IRS or liability protection.
Okay. So I'm gonna try to recap what you said. So someone from outside the state of Wyoming wants to have a Wyoming trust. They don't live here. Their options are they could set up a private family trust company, right, where they basically form an entity that serves as the trustee, and that's a slightly regulated process. Is that fair to say, or it's not really regulated at all?
No, the articles that you file with the Secretary of State, I mean, it's regulated to the extent that any LLC in the state's regulated, but it's there's a couple of things you have to add to the articles of organization, but it's like the Banking Commission isn't regulating it.
Got it. Okay. Next option would be you could hire like a traditional trustee, like a bank that had a trust department, right? And they could serve as the trustee, and they're obviously in the state of Wyoming. Or you could go to a chartered trust company that's actually been licensed and regulated by the State Division of Banking, and they can take possession of assets and manage them for you and serve as a trustee. Did I more or less say that right?
Yeah. Yep. And there's different iterations too with, sometimes you can pull in trust advisors. So the traditional corporate trustee would, be the kind of the main entity that's locating the trust within the state, or allowing us to make it a Wyoming trust. So they're kind of called or sometimes called situs trustees. But they anchor us within the state of Wyoming, and then we can have trust advisors come in and serve on, like the financial side or sometimes distribution side.
So then to add a layer of complexity where it gets a little tricky though, if you're going to take one of the options where there are professional trustees, like a charter trust company or a traditional trustee, not all of them handle every type of asset. Is that correct, Jerry? So again, use me as the example. I'm from out of Wyoming. I want to come in and I've got real property in Rhode Island, and bars of gold in, some vault in Florida. Not every trustee might be able to manage that, or the business services that they provide might not facilitate that. Is that fair to say?
Yes, that's one of the keys we use when we sort of having our client interview and asking them questions. One, it's a matter of helping them out, creating the document and the trust agreement, but it's also seeing who would be a good fiduciary to help facilitate all of their business transactions and the types of assets that they have. So, for example, cryptocurrency is a huge one, very hot topic, and there are a few trustees within the state of Wyoming that can effectively manage those assets. And so we usually try to tie those clients with the fiduciaries that we think would be most beneficial to the types of assets that they have and who has the experience managing those assets.
Because I suppose, and this is one of the things that we're getting a lot of calls on in our firm. You just mentioned, Jerry, regarding crypto or digital assets. It's a little different though, right? Because crypto for the most part is a bearer instrument, right? So proving where that property sits at, for the trustee purposes is a little bit amorphous, right? It's kind of hard to demonstrate. Whereas if it's a piece of property titled in some state, or physical, property that's held by somebody in some state, that's kind of easy to determine. What do we tell clients when they call and say, hey, I've got, a bunch of crypto. I live in Florida. I really want a Wyoming trust. I don't qualify, right, as being a person that, under a revocable or irrevocable trust. Maybe I'm not going to rise to the level of needing a professional trustee, or I can't find someone that will serve as my professional trustee. What are their options, right? What are they most likely to do if they want to try to custody those assets in Wyoming for Wyoming legal purposes?
I mean, usually it's not a trust, right? So the people who call in, they're looking for, lots of times they're looking for anonymity. Anonymity just meaning that it's already anonymous to a certain extent, but wanting to remove it even further. So typically what they do is they just have an LLC organized within the state. The way that you accomplish anonymity is by making sure that you're, if it's me who's setting up the LLC, right, that it's I'm not the one serving as organizer, so somebody else's name is on there for that. LLCs are required to have a principal place of business, a mailing address, and a registered agent. All three of those, if they're my address, it's not anonymous, right? If there's some companies in the state that allow virtual offices, which is a little bit higher of a use, but they also just allow sometimes for you to utilize their addresses for the principal place of business and mailing. So lots of times folks call in and they want, liability protection as well, but anonymity typically is the larger thing that they're looking for, both of which can be accomplished in the LLC context.
So is that more often than not what people are probably needing is an LLC that they can title digital assets into, and then the trust that they might have in their home state can own that LLC, right?
Yeah, and that's where we usually come in. So it's we'll help folks out in organizing or coordinating with another company to organize in either event to organize the LLCs, preparing the operating agreement and organizational meeting minutes, as well as, like you said, identifying the wallets that they will be contributing over, which is one part of it that shows that it's an intent to have it be a Wyoming custodied asset, as well as working to retitle essentially some of those assets to the extent you can as well. The estate planning piece, right? It still fits within that revocable trust plan, or if there's some irrevocable planning that we would need to do, all of that can fit, together.
Okay, so John, switching gears just a little bit, maybe for our viewers, talk a little bit about the tax considerations, with the different kinds of trusts and the plans that we're contemplating. Are there certain thresholds of assets that make sense for different things, or are there different tax considerations that play in for some versus the others?
Yeah, so the driving factor for a lot of irrevocable planning is the federal estate tax exclusion amount. So the big beautiful bill had made permanent some of those exclusion, or the heightened exemption amount. So it's in January of 26. It's going to end up being, I think, $15 million per person. There's a concept called portability, which just means that spouses are able to combine their exclusion amounts in order to. So if I die in year one, my wife can port over my unused exemption. So it's when we're talking about whether irrevocable planning makes sense, irrevocable planning or using some of those irrevocable trusts they make a lot more sense when you actually hit a point that federal taxes will apply to you. Part of the reason that it also makes sense to have attorneys in a state where you're not necessarily a resident do some of that planning is that federal estate tax planning is largely you're planning for federal law. And the impact of it. So, all of that is on a federal scale, not necessarily a state by state scale. So some folks look to Wyoming because our tax environment is very, very, very forgiving. Lenient maybe is the better word, but it's really when we get folks that are approaching that federal estate tax threshold that it makes a lot more sense to start doing or putting in place some of those other elements. So, it could be anywhere from, if it's an individual, if you have assets or your net worth is north of $10 million, it's worth a conversation. Maybe we're not doing that planning yet. But once you're over that, or you get really clearly over that threshold, I mean, that's just what your estate planning looks like at that point. Conversely, when you're under that, or you're not close to it, right, which most people aren't, then irrevocable trusts don't typically make sense.
Got it. Okay. Jerry, I'm going to completely switch gears for a second now and throw something out of left field at you. There's been, really national news coverage and sort of a national conversation around something that's become known as the cowboy cocktail. So maybe start by just orienting our listeners and viewers. what is the cowboy cocktail, right? And what are people using this cocktail for, I guess, is the best way to put it.
Yes. It's one of those planning tools that I have no idea how the name came to be, but it's irrelevant at this point. But under the basic premise for Cowboy Cocktail, it's essentially having a domestic asset protection trust. Under Wyoming law, we call it a qualified spendthrift trust that is owned by a LLC. That owns an LLC, and the LLC has certain assets below it. So usually that comprises digital assets and some other real estate holdings that some clients want to protect. And under the basic sort of setup, that is the Cowboy Cocktail. Now, obviously, we could unpack that a little bit, especially at the domestic asset protection trust level. Is how does it apply? How does it work? What are the certain fiduciaries, what they can and cannot do? There's a little more planning that goes involved there. But in terms of the basic structure, that is the Cowboy Cocktail.
So why do most people want the Cowboy Cocktail? Well, I shouldn't say most people. The people that call wanting to, explore the Cowboy Cocktail, what's their motivation for wanting this?
I think the motivation is asset protection. I think they have, some assets, some in terms of the calls I've gotten, some range from 30,000 and up. And I think they're all wanting to protect assets. I think they had a Cowboy Cocktail, and it's a good asset protection tool and technique that many people are trying to flock towards and try to get to. It sounds fancy, I think. And, I think everyone presumably thinks they need one if they have, some assets that they want to protect, and they think that certain creditors could get a hold of it. And, with our LLC laws, about the charging order, and they think having the domestic asset protection trust on top of that would add an extra layer of protection, which it does. But it really, based on some of the assets they have, it's really not a necessary tool, but they still want it.
So when we talk about asset protection, really what we're talking about is liability proofing as much as we can, right? And making it so potential creditors or judgment creditors, it's as hard for them as possible to either find the assets or to, right, determine who the ultimate beneficial owner of those assets are. Is that a fair way to put it?
That is correct. In terms of most of the calls I receive regarding those domestic asset protection trusts, yes. And it is an irrevocable trust. So there is that component to it, which, again, if you have, like John was saying earlier, if you have that threshold for estate tax exemption, it could be a great trust to use. But if you don't qualify for those types of exemptions in terms of the estate tax, it's really expensive and cumbersome to manage. And I don't know why a client would want to go through the process of wanting to set those up.
Okay, so another question about the Cowboy Cocktail, John. I mean, we know that anonymity is a big driver of this, and that sparks a policy debate on whether Wyoming should be or shouldn't be, providing mechanisms for people to hold assets anonymously. But aside from just that, like, what are some of the reasons that you see that people either do or don't benefit, or would or wouldn't benefit from something like that?
Yeah, there's very valid reasons why anonymity would be a good thing and a valid thing and a legitimate thing to have, right? So lots of companies, I think it makes a lot of sense. I think the disconnect becomes, do people actually need this, right? And I think the underlying concern that people have is, how do we keep our assets anonymous and how do we protect them from liability? And so part of our job when people call in is to say, okay, well, you've found these things on the internet and articles, wherever, right? Very, very legitimate estate planning practice or liability protection tool. But most folks don't need it. If their concerns are that they still want to use their assets day to day, they want to be able to rely on them. They want to be able to quit their quit their day job and be able to rely on their ability to trade or exchange or whatever, right? Then it makes a lot less sense to tie up those assets in something as restrictive as an asset protection trust. And maybe, an LLC is a better fit There's always conversations about the business purpose, whether we'd be able to get that corporate shield for the way that we're using those assets, just because, if you're not using them for a business purpose, and that's something, it's a big, long factor test that I think every one of us works through in every single case. But, if we can fit it within that purpose, then an LLC allows people to have the anonymity by utilizing another entity that will allow us to organize it and use their primary, their address as your place of business, a mailing address, as well as a registered agent. So you get the anonymity there. You get the liability protection through our, the LLC statutes that Wyoming started in the 70s. So it's nothing, different about the asset, although, Wyoming's incorporated some statutes about the digital assets, particularly in the context of LLCs, which I think is helpful. But do people need it? Most folks don't. I think most folks are more in the context of something that, if we're under the estate tax exemption amount, then lots of times an LLC makes a lot more sense than going through a more restrictive and expensive process. Well,
and if I have one more person send me an Instagram reel with some concoction they see on there about, you form a Cayman Foundation and then a Wyoming LLC and you create a fake promissory note and you pay yourself, and it's like, yeah, that's tax fraud. It's tax fraud is what that is. I feel like a lot of people just have these misconceived notions about, right, the way to use these tools and what these tools ultimately really provide. So, yeah, this has really been helpful, guys. Thank you.
Yeah, thanks for having us.
Thank you.
Thanks for joining us again for another episode of the Hathaway Kunz podcast. Hopefully you enjoyed today's discussion. Please stay tuned for our next episode where we'll unpack all things legal in the state of Wyoming.